shall not be infringed. Now those words have a little bit more oomph behind them after a 6-3 decision from the United States Supreme Court. We've got the opinion up right here, coming out near the very end of the October term, and it is a big one. The left is very upset about this, but the God-loving Americans who cherish their right to keep and bear arms are very excited about this, myself included. We're going to go through it. You can see that we're only going to spend some time today on the syllabus, the head note of this. It's about 6 pages. There is some heavy lifting, some legalese that we'll work our way through. But the whole opinion, if you can see this up at the top, is 135 pages. And so we're not going to cover it all here. We're going to hit the syllabus, which should give us the nuts and bolts of what is included in the rest of the opinion. And then we'll see what the governor and what Joe Biden have to say about this. A lot of them very upset. Of course, this comes out right in the context of Uvalde and some other, short shootings. And we see a lot of news about this in the media. And so the left will go bananas over it. But let's dig into this and see what we've got here. As a reminder, this head note here, this paragraph tells us about what the syllabus is. It says that when released and when it's feasible, they're going to include a little synopsis of the full opinion for us to unpack. And the case, of course, is New York State Rifle and Pistol Association versus Bruen. And the case is being referred to by this name most regularly. So you see that name, that's really what they're talking about. And that's probably how it's going to be referenced moving forward. We think about a common case right now, right? Roe versus Wade. Probably Bruen is going to be the name that we hang on to and latch onto as this follows around the courts and everybody interprets what this opinion means. All right, so it tells us, decided June 23rd, 2022, and this is the summary of the facts of the case. The court tells us the state of New York makes it a crime to possess a firearm without a license, whether inside or outside the home, meaning you've got to have a license in order to possess a firearm. An individual who wants to carry a firearm outside his home may obtain an unrestricted license to, quote, have and carry a concealed pistol or revolver if he can prove that proper cause exists for doing so. So he sort of has to be the person who shows I'm allowed to have a firearm. An applicant satisfies the proper cause requirement only if he can, quote, demonstrate a special need for self-protection, distinguishable from that of the general community. So before you can get this license or this permit, you've got to make an affirmative showing. You don't just get it by default. You got to prove some special need for it. We have the petitioners, the people who brought the lawsuit. We've got Brandon and Robert. They are adult law-abiding New York residents. Both applied for unrestricted licenses to carry a handgun in public based on their generalized interest in self-defense. A couple of guys say, we want to have firearms to protect ourselves. The state denied both their applications for unrestricted licenses, allegedly because both Koch and Nash failed to satisfy the proper cause requirement. As I said, they didn't meet the elements. It wasn't justified enough. Petitioners, Robert and Brandon, both then sued state officials who oversaw the licensing applications. They asked the court for declaratory and injunctive relief, saying, court, tell them that what they're doing is wrong and make them give us the permits. And in this lawsuit, they were saying that they violated the Second and the 14th Amendment rights by denying their unrestricted license applications for failure to demonstrate a unique need. The district court dismissed their complaints. Okay, so it said, hey, Brandon and Robert, sorry guys, get out of here. Dropped it back down. Both courts relied on the Second Circuit, their prior decision, which said that New York had the appropriate law in place, saying that this law was substantially related to the achievement of an important governmental interest. So it sort of passed the scrutiny standard that they said applied here, and they were allowed to reject those permits for those two gentlemen. Supreme Court comes out and says, wrong. New York's proper cause requirement in the law violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms for public self-defense. In public for self-defense. Meaning that's a pretty basic interpretation right there. Violates the 14th Amendment. It prevents law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms in public for self-defense. Pretty clear. All right, in District of Chicago, Columbia versus Heller, this is how they refer to the other big gun law case. And McDonald versus Chicago, the court held the Second and the 14th Amendments protect an individual right to keep and bear arms for self-defense. So we set that baseline. You do have a right to keep and bear arms for individual self-defense. Under Heller, when the Second Amendment plain text covers an individual's conduct, the Constitution presumptively protects that conduct. And to justify a firearm regulation, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. And we're going to see that, I think, in future cases. Historical tradition of firearm regulation. And there really wasn't much, right, until pretty recently. They were sort of, even when you sort of look back on those old novels and stories and the stories from the founder and the founding era, they would tell us regularly, that they would sort of arm up their 13-year-olds. And, everybody sort of was immersed in firearm culture, which is why they put it there in the Second Amendment. Since Heller and McDonald, the Court of Appeals have developed a two-step framework for analyzing the Second Amendment challenges that combines history with means and scrutiny. Right now, we're going to get into a little bit of heavy lifting here legally. The court rejects that two-part approach as having one step too many. Okay, so now this is saying, hey, Court of Appeals there, out of, I believe it was the Second Circuit, step one is to broadly and consistent with Heller that they had, which demands that the test is rooted in the Second Amendment's text as informed by history. But Heller and McDonald do not support the second step that was imposed by the Court of Appeals. Heller's methodology centered on the constitutional text and the history. It did not invoke any means-end test like strict or intermediate scrutiny, and it expressly rejected any interest-balancing inquiry akin to intermediate scrutiny. And what they're talking about is up previously when we were reading what the court was doing, you see the sentence here, the New York government, the people who passed this law, and the New York courts, when they were interpreting this, the district court dismissed this because they said this standard, the substantially related to the achievement of an important governmental interest, was satisfied. And this is a constitutional standard. And we spent a lot of time on this on the show, sort of differentiating between the three different standards or the different levels of scrutiny. When you have a constitutional right that is being infringed upon, okay, we have a right to free speech, a right to keep and bear arms, many, many other rights that we talk a lot about that are being trampled upon all over the place. Theoretically, under our Constitution and according to our Supreme Court, when the government tramples on those rights, we go through some sort of analysis and we say, can the government do that? Like they trampling on that right, but is that okay? Or not. And we go through these three different tests essentially, and there's balancing tests and you're weighing different factors, and you've got these three different, briefly general levels. One's called the rational basis standard, the other is called intermediate scrutiny, and the other is called strict scrutiny. And when you have a very important, very protected constitutional right, the government is supposed to apply the strict scrutiny standard because the government is infringing on that right. And the government must be held, it absolutely has to need to infringe on that right. Like there's got to be no other way. It has to be necessary, least restrictive means, all of this stuff in order for that to be valid. And, that type of stuff typically applies to broad constitutional rights that we enjoy. Here, though, what you can see, it says substantially related to an important government interest. And that's not that highest standard. That's actually that intermediate standard that is sort of in that gray area between the two, strict standard and the rational basis standard. The rational basis standard is really saying that, if the government is not infringing on a constitutional right, they don't really have to do anything. I mean, if there's any rational basis for what they want to do, then they can do it because it's not infringing on your rights. It's the government. If it's like a legitimate government purpose or a legitimate function, yeah, they can basically do it. But if it is infringing on your rights, well, then we got to really, hey, hold on a minute now. Let's put this under some strict scrutiny. Let's really look at this thing to make sure that you can infringe upon those rights. So back down here, the court is going through some of that analysis, and they're saying we have expressly rejected any interest balancing inquiry like intermediate scrutiny. All right. Like we never even thinking about this here. So rejected. Historical analysis, writes the court, can sometimes be difficult and nuanced, but reliance on history to inform the meaning of constitutional text is more legitimate and more administratable than asking judges to make difficult empirical judgments about the cost and benefits of firearm restrictions, especially regarding their lack of expertise in the field. What the judge is talking about here is the difference of interpreting the Constitution. Okay, some people will say the right to keep and bear arms shall not be infringed, and they'll read it and they'll say, all right, well, that to me means shall not be infringed. And so how do we interpret that? I mean, I would take a look at it and say that if you pass laws and regulations that infringe upon that right, meaning it makes it more difficult to access and enjoy that right, that's an infringement. It's pretty clear. But a lot of other people make it very complicated. And then, well, what does the right to keep and bear arms mean? And what does arms mean? And what does infringe mean? And weren't they militia members? And what does that mean? You can have a cannon and a nuclear weapon, and they go off all these, crazy banana arguments. It's nonsense. But they go down that route. And so we have to, in the legal field, really unpack all of this. What does it mean? How does it all settle? And of course, there is a lot of nuance there. One approach is to go back in time and to say, well, what did they mean when they wrote this down? What did they say about this back when they actually wrote the Second Amendment? We can look at what they were publishing in their other journals. We can look at the publishing documents that were a part of the debates when they were crafting these documents, right? During the constitutional conventions, what were the debates? There were people taking notes, and their journals and their articles. And we read on our channel the Federalist Papers, some of them. And, there's a lot to add to the debate. What were the founders thinking? And the judge here is saying that's a better way to do this than to have current judges who are sort of now just apparently appointing themselves experts in the field of firearms. And they're going to be the people who judge the cost and the benefits of firearms restrictions. And they're going to sort of be like Congress people, right? They're going to be sort of like little mini legislators who just sit there and they say, well, I think that there's a lot of danger that's involved now with guns, just like we heard previously with Sotomayor and Breyer and Kagan during the COVID debates. We heard a lot of them say, well, there's a lot of deaths, and they were making policy arguments about why the the Health and Human Services Division was allowed to go in and basically steal people's homes from them, right? Seize their property rights away from them. And they were justifying this in all sorts of different ways. The court now, of course, is saying this is something where we can't listen to the judges who are appointing themselves the interpreters or the policymakers. We have to go back because it's more reliable. It's more administrable, I think is how you say that word. And he is saying that if you go back and refer to history, then you've got something upon which you can pin your arguments, versus if you're just some sort of judge who gets appointed and confirmed by the Senate, then you're just sort of making stuff up as you go along. You have no anchor upon which to base your opinions. Federal courts, he says, tasked with making difficult empirical judgments about firearm regulations under the banner of intermediate scrutiny often defer to legislatures. And while judicial deference to the legislative interest, balancing and it is understandable, saying, we have to say, what is the interest of the legislature? They want, obviously, to not have their citizens killed by guns, presumably. But we also have to protect the rights of people to keep and bear arms. So we're balancing these two things. And the court is saying, look, well, I mean, I can understand why that might make sense. While judicial deference to the legislature is understandable and elsewhere it's appropriate, it is not deference that the Constitution demands here, right? So we don't need to defer to them if they want to dump all over your Second Amendment rights. The Second Amendment, he says, is the very product of an interest balancing by the people. That's why we have it. We don't need a balanced interest on top of it. Itself is an interest, a balancing of interests. And he says, quote, it surely elevates above all other interests the right of law-abiding, responsible citizens to use arms for self-defense. Okay, that comes out of the Heller, the previous case. It is the very product of an interest balancing test by the people. It's already been debated. That's why it's in the Second Amendment. We don't need to add additional interest balancing tests on top. Well, now, do you really need the right to defend yourself? Like, now, do you now? I mean, it's 2022. Do you really need semi-automatic weapons of war, whatever they call it? The answer is yes. And we've already debated it. And it's the Second Amendment to the United States Constitution. There's no further conversation about it, okay? You, Kathy Hochul, you, Joe Biden, you, Michael Moore, you psycho people, don't get to suddenly recreate the debate over again because there are tragedies in the world. It's already been debated. It's in the Second Amendment. It's there. It's written. It's clear as day. Stop questioning it. And if you don't like it, there are remedies. You can do something about this, but you have to go through the legal mechanisms to do it. You have to go pass another amendment and do something about it to repeal it or to water it down in some way, shape, or form. And until you do that, it's pretty clear, it's codified, clear as day. And this Supreme Court opinion here confirms it and buttresses it again. Number 3, the test, writes the court, that the court set forth in Heller and applies today requires the court to assess whether modern firearm regulations are consistent with the Second Amendment's text and historical understanding. Okay, got to go back in time. Were there regulations back then? If the current regulations today are consistent with the regulations historically, they may pass constitutional muster. They may pass legal frameworks that regulate them. Of course, the regulatory challenges posed by firearms today are not always the same as those that preoccupied the founders in 1791 or the Reconstruction generation of 1868. But the Constitution can and must apply to circumstances beyond those founders specifically anticipated, even though its meaning is fixed according to the understandings of those who ratified it. Indeed, the court recognized in Heller at least one way in which the Second Amendment's historically fixed meaning applies to new circumstances. Its reference to, quote, arms does not apply, quote, only to those arms in existence in the 18th century, right? Obviously. Like it doesn't only apply to muskets, okay? To determine whether a firearm regulation is consistent with the Second Amendment, Heller and McDonald point toward at least 2 relevant metrics. Is it consistent with the Second Amendment? Regulation, banning any type of addition to, we talked about FRTs, right? And the rapid reset triggers and all sorts of bump stocks and things like that, right? These are all regulations. To determine whether a regulation is consistent with the Second Amendment, Heller and McDonald point toward at least 2 metrics. We got to sort of put them through this filter and see, are they in sync with one another? First, whether modern and historical regulations impose a comparable burden on the right of armed self-defense. A comparable burden on the right of armed self-defense. Armed self-defense, right? Not hunting, not sports shooting, armed self-defense. And we're talking about the actual right that's being burdened. Okay, now, a lot of people sort of will say, well, you can have a firearm, but it's got to be locked and disassembled, and you can only have one bullet, and it has to be in your neighbor's house under his bed. And you go, well, okay, well, I guess I have the right to possess a firearm, certainly, but something is, I guess my right to use it functionally is being burdened. So, they'll get sneaky with this. Well, you can possess a firearm, but you can't have any ammunition. So here we're talking about the burden on the right of armed self-defense. Armed self-defense, right? It's a core concept. And they try to water this down. They try to diminish it by saying, no, you can have a firearm, but you can't have any ammunition. Or you can have this, but not that. Or it has to be disassembled. It has to be stored in 35 different safes and pieced together like Legos before you use it. And the second here, which is whether that regulatory burden is comparably justified. The regulation, the burden, the justification. Because individual self-defense is a central component of the Second Amendment right, these 2 metrics are, quote, central considerations when engaging in the inquiry. And to be clear, even if a modern day regulation is not a dead ringer for historical precursors, it still may be analogous enough to past constitutional muster. For example, courts can use analogies to long-standing laws forbidding the carry of firearms in sensitive places like schools or government buildings to determine whether a modern regulation is constitutionally permissible. That said, the respondents' attempts, meaning New York's attempts, to characterize New York's proper cause requirement as a sensitive place law lacks merit because there is no historical basis for New York to effectively declare the island of Manhattan, seen here, a sensitive place simply because it's crowded and protected by the New York Police Department. So what the court is saying is, yeah, there is some historical context. You can go back in time and you can say, yeah, look, they did say, okay, no guns in the, in the town square or whatever, in the city hall. Don't bring your firearms. Check your firearms with, the sheriff out front before you bring him in here, whatever it is. And so that is all legitimate. That's okay. But New York is using that. They're saying, well, I mean, if you say that it's a special place at City Hall back in 1800, well, we're just going to say that the entire island of Manhattan in New York is just a sensitive place. It's kind of like City Hall, isn't it? Well, there's a lot of people. And so that was their argument. And the court said, no, that's not any good. Sorry, no. Having made the constitutional standard endorsed in Heller more explicit, the court applies that standard here in the proper cause requirement. Now, it is undisputed that petitioners Koch and Nash, two ordinary law-abiding adult citizens, are part of, quote, the people whom the Second Amendment protects. Look at Heller if you need more on that. And no party disputes that handguns are weapons, quote, in common use today for self-defense. So we got that box checked. The court has little difficulty concluding also that the plain text of the Second Amendment protects Cox and Nash's proposed course of conduct, meaning carrying handguns publicly for self-defense. Nothing in the Second Amendment text draws a home public distinction with respect with the right to keep and bear arms. Like, you can't only have the right to keep and bear arms when you're sleeping next to your spouse, protecting your children and your dog. Otherwise, it's illegal, right? It doesn't say that. Self-defense, it's the right to keep and bear and to protect your life, because you can't rely on the government to do that for you. You've got an obligation to take responsibility for that, because you call the police and we can see what happens, right? They show up when your school is under assault and they just hang out for an hour. Here, he says, the distinction doesn't exist, and the definition of bear naturally encompasses public carry, right? You're bearing it out. You're showing it to the world. You're not concealing it, right? It's not the right to keep and conceal arms. It's not the right to keep and lock up arms. Not the right to keep and train with arms at a shooting facility or during a war or using it for sports or hunting deer. Keep and bear them, to walk around and say, that's right, baby, look what I'm packing. It's clear, just from the word itself. Judge says so. Moreover, the Second Amendment guarantees an individual right to possess and carry weapons in case of a confrontation, referencing also, I believe, Heller. And confrontation can surely take place outside of the home. In fact, it's probably more likely to take place outside of the home, right? You do have internal home confrontations, and sometimes those can get not good. But you're typically waiting or wondering for an external threat that you were not expecting, right? Something that is unforeseeable to happen. The court continues, they tell us, the burden then falls on the respondents to show that New York's proper cause requirement is consistent then with the nation's historical tradition of firearm regulation. In other words, if we now set the appropriate baseline, we say, okay, look, regulations, according to the Constitution, can only be imposed when there's a historical tradition of them being imposed. When we reset that baseline, then we now have to take New York's regulation and apply it to that new rule. So let's do it. They say to do so, respondents appeal a variety of historical sources from the late 1200s, which is not here in the United States, to the, or not, I mean, pre-formation of the United States, all the way to the early 1900s. But when it comes to interpreting the Constitution, not all history is created equal. Constitutional rights are enshrined within the scope they were understood to have when the people adopted them, right? Its framework, its context. The Second Amendment was adopted in 1791, the 14th in 1868. And the 14th Amendment was sort of layered on top of, during the Reconstruction era, and it incorporated, we call it, a lot of the Bill of Rights into the states. And there was a distinction between those two things sort of before the 14th Amendment. And so those two dates are important. So they go back to that era. Historical evidence that long predates or postdates either time may not illuminate the scope of the right. With these principles in mind, the court concludes that the respondents have failed to meet their burden to identify an American tradition justifying the proper cause requirement. So he's sort of putting a a boundary around it, a hula hoop, as we say, to say this is what you can bring into the conversation about historical tradition. Okay, you can't go find a country somewhere in 1350 and say, well, they didn't want you to have bayonets when you went down to their ritual sacrifice. Okay, so that's all applicable to American tradition because Ben Franklin wrote about it one time in a letter in Poor Richard's Almanac, right? No. This is what we're talking about. Respondents' substantial reliance on English history and the custom before the founding makes some sense, given Heller's statement about the Second Amendment and codified rights that were inherited from England. But the court finds that history ambiguous at best and sees little reason to think the framers would have thought that it would be applicable to the New World. Right? That was an English ancestor law, not relevant here. That's why they left. The court cannot conclude from this historical record that by the time of the founding, English law would have justified restricting the right to publicly bear arms suited for the defense only to those who demonstrate some special need for self-protection, right? In other words, it wasn't like nobody gets it until you demonstrate the need for it. It was, you just get it. You don't have to come and show permission as to why you should get the right to keep and bear arms. Respondents, next, this is New York. New York says, hey, court, look at the history of the colonies in the early republic and take a look at these three restrictions when they were talking about carrying back in public at that time. And the court says, well, the court doubts that just three colonial regulations could suffice to show a tradition of public carry regulation. Even looking at these laws on their own terms, the court is not convinced that they regulated public carry like New York is trying to do here. All right, even when we go back and look at those regulations, the statutes essentially prohibited bearing arms in a way that spread fear or terror among the people, including by carrying dangerous and unusual weapons. Right? So like if you're carrying around a ball and chain and you're swinging it around in the bar, in the saloon, not okay. You can't do that. A lot of people there are trying to play cards and they're trying to have a good time and you're going to crack somebody's head open. So keep that at home. Here you see whatever the likelihood that handguns were considered dangerous and unusual during the colonial period, they are today the quintessential self-defense weapon, right? So they weren't all that unusual or aren't now. Thus, these colonial laws provide no justification for laws restricting the public carry of weapons that are unquestionably in common use today. Only after the ratification of the Second Amendment in 1791 did public carry restrictions proliferate. Respondents rely heavily on these restrictions, which generally fall into three categories: common law offenses, statutory prohibitions, and surety statutes. None of these restrictions imposed a substantial burden on public carry like what New York's trying to do here. So don't make the comparison. He talks about the three different categories of these. The common law offenses, as during the colonial and founding periods, the common law offenses of affray or going armed to terror of the people continued to impose some limits during the antebellum period. But there's no evidence indicating that these common law limitations impaired the right of the general population to peaceable public carry. Okay, you can't terrify people with it, but it didn't mean you couldn't public carry. So New York doesn't count. The default, even under those common law offenses, was still public carry. There were some statutory prohibitions. In the early to mid-19th century, some states began enacting laws that proscribed concealed carry of pistols and other small weapons, but the antebellum state court decisions upholding them evince a consensus view that the states could not altogether prohibit public carry of arms protected by the statute or state analogs. So saying that the states, even if they were upholding those prohibitions or those restrictions, they still weren't overturning or denying the general right to public carry, right? The default is still public carry. There's no where there's sort of the default is not public carry. Here, they also have surety statutes. They say in the mid-19th century, many jurisdictions began adopting laws that required certain individuals to post bond before they could carry a weapon in public. You know, post some money and then get the right to bear arms. Contrary to the respondent's position, meaning New York, these surety statutes in no way represented direct precursors to New York's proper cause law. While New York presumes that individuals have no public right to carry without showing a heightened need, the surety statutes presumed that individuals had the right to public carry that could be burdened only if another could make out a specific showing of reasonable cause to fear an injury or breach of the peace. So it sounds like you had the default until you did something, and then they would take it away from you. You'd have to post a bond in order to get it back. Thus, Unlike New York's regime, a showing of special need was required only after an individual was reasonably accused of intending to injure another or breach the peace. Even then, proving special need simply avoided a fee, right? So it's just posting money up, essentially. We'll give you your gun back, but if you shoot somebody, you're going to lose the money that you deposited with us, okay? Just so you're aware. It's like, all right, I have to really think if it's worth it then. In sum, the historical evidence from antebellum America does not demonstrate that the manner of public carry was subject to reasonable regulation, but none of these limitations on the right to bear arms operated to prevent the law-abiding citizens with ordinary self-defense needs from carrying arms in public for that purpose. Evidence from around the adoption of the 14th Amendment also does not support New York's position. The discussion of the right to keep and bear arms in Congress and in public and in discourse, as people debated about whether or not to secure the constitutional rights for newly free slaves, generally demonstrates that during the Reconstruction era, the right to keep and bear arms had limits that were consistent with the right of the public to peaceably carry handguns for self-defense. The court acknowledges 2 Texas cases, saying there was a reasonable ground standard for public carry analogous to New York law, but the decisions were outliers and provide little insight into how this works in post-antebellum America. Post-bellum America. Finally, and we're almost done here, you can see we've got this last page. Finally, respondents point to the slight uptick in gun regulations during the late 19th century, saying, Judge, there is an uptrend. I mean, yes, maybe there was little regulation back in the early foundation of this country, but that started to change pretty dramatically as society evolved and we started to realize, oh, these guns are pretty dangerous. And so they're saying that shows that this trend is supporting historical regulation, therefore we should be also justified. As the court suggested in Heller, however, the late 19th century evidence cannot provide much insight to the meaning of the Second Amendment when it contradicts earlier evidence. In addition, the vast majority of statutes that respondents invoke came from Western territories. The bare existence of these localized restrictions cannot overcome the overwhelming evidence, an otherwise enduring American tradition of permitting public carry. Moreover, these territorial laws were rarely subject to any judicial scrutiny. There weren't even courts out there. And absent any evidence explaining why these unprecedented prohibitions on all public carry were understood to be in comportment with the Second Amendment, they do little to inform their origins and the continuing significance of the amendment, right? Why are they related to the Second Amendment? How do they support or detract from that? I mean, were there judges out there? Were there courts out there in these territories? Were these just sort of people trying to pass laws to gain control over wild areas? We're talking about the founding of the Second Amendment. Okay, did these influence the Second Amendment? No, they didn't. Okay, so here, finally, those territorial and these restrictions deserve little weight because they were consistent with the transitory nature of the territorial government. They were very short-lived. Some were held unconstitutional shortly after the passage, and others did not even survive the admission into the United States. So nice try. Also, after reviewing the Anglo-American history of public carry, the court concludes that respondents have not met their burden to identify an American tradition justifying the proper cause requirement. Apart from a few late 19th century outlier jurisdictions, American governments simply have not broadly prohibited public carry of commonly used firearms for personal defense. Just hasn't happened. Nor have they generally required law-abiding responsible citizens to demonstrate a special need for self-protection distinguishable from that of the general community and the right to carry in public. Finishing, the court says, the constitutional right to bear arms in public for self-defense is not a second-class right subject to an entirely different body of rules other than the Bill of Rights guarantees. The exercise of other constitutional rights does not require individuals to demonstrate to government officers some special need. The Second Amendment right to carry arms in public for self-defense is no different. New York proper cause requirement violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their right to keep and bear arms in public, and therefore reversed and remanded by Judge Thomas. Signing off on the opinion, he's joined by many others, and there's concurring opinions, and there, of course, are dissenting opinions by Breyer, Sotomayor, and Kagan, who are the lefty judges. And they are, you can see, they're very, very big opinion. There's a lot here if you really want to unpack it. And of course, I'll leave that to you to read through the rest of this at your leisure. But this is the Supreme Court opinion, 6-3. Big victory for the Second Amendment and for people who understand what it means and why it's so important. So it's a good day for many, except many on the left who are unhappy about this, starting with Kathy Hochul, who is the governor of New York, which is where this law was in place. And this is going to be something of consequence for, of course, New Yorkers. Right now, their law on this is all right in the trash. The Supreme Court said, sorry, guys. So you might see people walking around strapped up because their law is unconstitutional. Here, Kathy Hochul says, it is outrageous that at a moment of national reckoning on gun violence, the Supreme Court has recklessly struck down a New York law that limits those who can carry concealed weapons. She said, in response to this ruling, we are closely reviewing our options, including a special session of the legislature. To do what? Just as we swiftly passed nation-leading gun reform legislation, I will continue to do everything in my power to keep New Yorkers safe from gun violence. And it's okay. It's like, okay, this guy's got it great. Matthew Culkin, take the loss, Kathy, or we will see you back in court. Did you hear what I just read, Kathy? Did you read the opinion? It's basically saying any regulations that are not historically tied to regulations that the founders envisioned or that were already in existence are not valid. So yeah, go meet with your legislator, see what you come up with. I mean, hope you can come up with anything new that you like, but if it's not new that matches something that was old, well, then it's not going to be applicable. It's going to go bye-bye. Kathy was very upset about this, and here she said this today. Let's listen to this little soundbite. And I think I have to switch the audio so that you can hear it. I apologize for that. Bear with me 1 second. And we're going to swap that now. Here it is.
And I'm sorry this dark day has come. That we're supposed to go back to what was in place since 1788 when the Constitution of the United States of America was ratified. And I would like to point out to the Supreme Court justices that the only weapons at the time were muskets. I'm prepared to go back to muskets. I don't think they envision the high-capacity assault weapon magazines intended for battlefields as being covered from it, but I guess we're just going to have to disagree.
Okay, so obviously, another stupid argument. They continue to revert back to the same old talking point. It's about self-defense. It's about protecting your life and your liberty. You don't just get to say, you only get muskets and one bullet, and you can only use it on Thursdays between the hours of 2 and 7, right? It's ridiculous. It's about a more fundamental principle, but they don't see it that way. They start to, decipher it by magazine size and by, different additions or subtractions to the entire firearm conversation. It's ridiculous. And we also know that poor President Biden is also unhappy with this. He said this, President Biden, quote from Kyle Griffin. Kyle Griffin is over from MSNBC, executive producer over there. So he's probably pretty plugged in with Biden. Biden says, quote, I am deeply disappointed by the Supreme Court's ruling. This ruling contradicts both common sense and the Constitution and should deeply trouble us all. I don't think so. I mean, I think it's pretty common sense what the Second Amendment says. And I think that this is a pretty important right that is now nicely buttressed by the Supreme Court, and I'm pretty happy about it. The U.S. Department of Justice also came out with a statement, and here, this came over from Jennifer Van Laar. She writes for Red State, and she said that the DOJ statement came out, and then they're wondering, she says, read this statement and then ponder the fact that the Senate gun bill, the DOJ will fund In the Senate gun bill, the DOJ will fund the grants enabling the development and the enforcement of red flag laws in state capitals. They're not interested in protecting your constitutional rights, which is 100% true. This point being that the DOJ, well, let's read this. It says, the DOJ today released the following statement after the ruling. We respectfully disagree with the court's conclusion that the Second Amendment forbids New York's reasonable requirement that individuals seeking to carry a concealed handgun must show they need to do so for self-defense. They say it's reasonable. You should have to have that requirement to show that you need it. You don't automatically get it. You have to show need. The Department of Justice remains committed to saving the lives by enforcing and defending federal firearms laws, partnering with states using all legally available tools to stop the epidemic of gun violence plaguing our community. Okay, so it's basically a dead statement. But meanwhile, as Jennifer Van Laar told us, right, there's a bunch of Republicans and Democrats all conspiring right now to pass gun regulations that will basically ask states to infringe upon people's rights to keep and bear arms by doing it using the power of the purse, by using Congress and federal funding to say, pass these regulations, infringe on these rights, and if you do so, we'll give you some extra money that you can use. And of course, we know how much the local state politicians love that federal government money. So we'll continue to follow those Republicans and this saga, but a very good day for the Second Amendment in the United States of America. Judge Thomas coming out, big 6-3 opinion that codifies this for many, many future generations, that says the right to keep and bear arms, self-defense, the ability for free law-abiding citizenry to maintain and enjoy those rights shall not be infringed. Pretty clear. And a good day. Very happy about that. Let me know what you think about it down in the comments below. Give me a thumbs up if you're also pretty excited about this. Before you get out of here, I want to invite you to join us on our membership, whether you're on a member on YouTube or join us as a member on Locals. We have videos. I put out videos basically every day. We have a member mastermind coming up, and I look forward to having you there and joining us on all of the other conversations that we're having outside of these great discussions. And my friends, thank you for watching. I look forward to seeing you on the next one.